typically credit cards, medical bills, even student loans, even though they're non-dischargeable, are considered unsecured debt because they don't specifically have some collateral against you that they can collect against if you don't make your payments. So usually the only option available to those creditors would be to sue you and then to try to do garnishments or to try to potentially even have the deputy sheriff show up and try to grab assets and that type of thing. So there are limitations in terms of what they can do that are not available with the secured creditors. Now, as you pointed out, though, even now, given the way the economy is, certain secured creditors are in tough shape because, say, if you have a second mortgage, at one point the banks were feeling pretty good about the fact that if they didn't make the payments, they could foreclose on the second mortgage and get paid off.
They were doling that stuff out like candy. Now they just pulled back big time, haven't they?
Well, that's a big problem right now. And in fact, one thing I advise a lot of my clients about, because some of them ask me, well, am I going to be able to get a mortgage? And in theory, a couple of years ago, people really could get mortgages a year or two out of bankruptcy. Now, even if you have very good credit, it's very difficult to get a mortgage. So I see a lot more of people going with land contracts and lease to own and that type of option. And it's worked out actually very well for people. You know, people are kind of backing away from the banks a little bit and taking more of their financial affairs into their own hands, which I actually think is a good thing.
Yeah, you don't have to pay as many fees on a land contract as you do, say, a mortgage.
That's true.
One thing that you should tell everybody when they go to court is to tell the truth, but false statements in a bankruptcy court will not do you any good, will it?
Oh, no, false statements. And in fact, I frequently will have clients come in and suggest to me, oh, should I put this in someone's name, or I don't need to tell the court about this asset. And I always tell them, look, you have to disclose everything. The truth of the matter is, most people, as they go through this process, we're going to be able to protect all their assets. We're going to be able to protect their income because of the fact that the bankruptcy laws actually in the United States, and this is really something we should all be proud about, are relatively pro-debtor, at least compared to certain other countries. Now, some people may say, oh, that's a bad thing. People get out of their debts. But we have to remember, there's a reason it's in the Constitution. And the reason it's in the Constitution is because this is a way that we're able to keep our economy moving forward. Other countries that do not have such progressive bankruptcy laws as we do in the United States, even after the change a few years ago, have really had a hard time getting out of economic hardship. For example, Japan. You know, even though we're going through a hard time right now, Japan went through 15 years of a serious recession in the 1990s and really up through now. And
did they change their bankruptcy laws?
You know, they actually have made some changes in them. You know, but part of the reason that critics have said is the reason for the fact that Japan has had so much trouble getting out of this is it's not possible for companies to kind of go through a process, reorganize their debts. Same thing for individuals, because when you're busy just paying on your debts and you're trying to survive, it kind of takes you out of the economic equation for the country. And our goal as a nation is to get you back into that economic equation so you can start contributing to the economy again.
And charging and paying it off and things of that nature, right?
Well, you know, that's the way the economy works, like it or not.
Chapter 7, liquidation, and that's what people sort of strive for, I would imagine. They want to get rid of the debt. There's a lot of exemptions that people don't really realize, and there's no reason to make up anything for the typical bankruptcy person. Is that correct?
That's absolutely right.
And why don't you tell them about some of these exemptions?
Yeah, well, absolutely. And, you know, for example, one of the exemptions would be for vehicles. You know, they have vehicle exemptions available. They have exemptions available for your household goods and furnishings. They have exemptions available for your clothing. They have exemptions available for jewelry. People often are really concerned that as they go through this process, they're going to lose things. And really, again, that's just not the case most of the time. The other thing, too, is that the courts have ruled that the kind of valuation we need to put on these things is what's called liquidation value. So say you spent, you know, $50,000 or something like that filling your house with furniture and pictures and all kinds of things over the years. The truth is, if you were to try to have a garage sale right now or sell them on eBay, you'd get a tiny, tiny fraction of that. And that's really the valuation that the courts look at as they're going through this process.
And that brings up a good point. The bankruptcy court does not want to turn into a garage sale.
No, not at all. In fact, I think it's 90% or more of the cases that go through are what are called no asset cases, which is basically where the trustee in the case representing the creditors says there's nothing here for the creditors, just let the debtor go forward, get his or her discharge, and then get back with their lives.
You mentioned something about reaffirmation. You can come back and say, I'll take and pay this debt, save this collateral, and I can get on with my life. What exactly is a reaffirmation of a debt?
Well, it's actually, the courts are required to essentially oversee this process because they don't want creditors kind of backdooring the process and going around to the court and saying, hey, look, keep paying us and we'll do one thing or another. So everything has to be on the up and up. Everything is in public. The courts oversee the process, and if you're represented by an attorney, your attorney needs to sign off on any reaffirmation agreement that goes forward. If it appears that the reaffirmation agreement will cause you certain undue hardship, then you need to go in front of the judge to essentially explain to the judge how you're going to be able to make these payments going forward. And if you're not represented by an attorney, then you need to go in front of the judge to explain the same thing. The reason for this is essentially when you're reaffirming a debt, you're taking a debt that would have been discharged in the bankruptcy and saying, I'm going to pay this anyway because I want to keep the collateral or I want to keep a relationship with my credit union. Credit unions will sometimes do reaffirmation agreements. And so the courts really look very seriously at these matters because they don't want somebody going and reaffirming debts where they really can't afford to pay them and in a few years end up in the same situation that they're in to start with.
Because it defeats the whole purpose.
It defeats the whole purpose. And the truth is, despite what some people may think, the bankruptcy courts really do not want people filing bankruptcy. There really is an effort to try to move people through this process and let them get on with their lives.
A preference, there's probably a good segue here. A preference is paying someone off a little bit early in the bankruptcy courts or giving them a preference. Do not like this.
They do not like this. And in fact, I'll tell you, one of the most serious things, and I would really advise people about this, is if you have a debt to a relative, do not pay it back right before filing bankruptcy, because that's one of the most serious things. And actually, I've had clients where they made a payment on a debt to a relative, a sister, brother, friend, whatever, and that person has ended up being sued by the trustee in the bankruptcy case to get back the funds that were paid prior to filing bankruptcy.
And it's a 90-day period.
Well, right? It's 90 days for credit cards, but actually with a relative, it's a year.
Whoa.
So it's a very serious matter, and you want to be very careful not to do. One of the things I always tell my clients is anything you think that you can do, any game that you think you can play through this process, someone else has tried it before you, and they figured it out. As you pointed out earlier, the best thing to do is be honest and try to be fair, and if you do that, 9 times out of 10 it's going to work out fine for you.
And like I'm sure in your Bankruptcy 101, the whole purpose is to get people back on their feet.
Exactly right.
Otherwise, they would defeat the purpose. Chapter 13, what's the difference between, say, the 7 and 13?
Chapter 13 is where you're going to make certain payments on your creditors going forward. So again, this is the
100%
chapter,
payment? Or?
Not necessarily. In fact, I'll tell you, probably most of my clients pay 0 or a very, very small percentage to their creditors. The reason, though, that this exists, there are 2 reasons why I'll generally suggest to someone to file
because you're a good
13.
attorney, but is there another reason?
Well, generally 2 reasons. One is that they want to keep a home that they've fallen behind on their mortgage payments. And pretty much once the mortgage company has decided they're going to foreclose on you, the only way to stop that foreclosure sale is by filing Chapter 13 bankruptcy and getting caught up on your mortgage payments through that process. The other reason why I've suggested to people to file Chapter 13 has been if they have a lot of debt, they want to file Chapter 7, but they have too much income to qualify. And if that's the case, then Chapter 13 can be a good option where they pay back a certain percentage of their creditors based upon really a calculation that we're able to perform as attorneys for them. And we figure out what the payment's going to be, and it allows them to really deal with the creditors without having to be garnished, without having various creditors trying to tear you apart and sue you and that type of thing. And it really can offer a good option for some people in that situation too.
And as a general rule, these people are in Chapter 13 have regular income.
Absolutely. That's one of the requirements. You cannot, it doesn't necessarily mean that you have to have a job, but it means you have to have a regular source of income. So say, for example, if someone has a pension, that could be a regular source of income, or your own business, that's also a regular source of income.
The automatic stay, that's one of the reasons why they go to the attorney like yourself or buy the book,
right,
is because they're getting garnished or they're getting foreclosed upon, and this automatic stay or their car gets repossessed is a very powerful tool. Maybe you can address what you've seen in the bankruptcy court. And if anybody has any thought about going against an automatic stay or proceeding against someone who's filed bankruptcy, you better think again, right?
Oh, you got that right. No, it's a very powerful tool. And it's really, you're right. I mean, that is the primary reason that people will initially file bankruptcy. As soon as that stay occurs, any garnishments, any collection efforts, even the phone calls from your creditors all have to stop. And they do typically because they realize the kind of trouble they can get into if they don't comply with the automatic stay. The law allows us to get punitive damages against a creditor if they willfully violate it. Yes, and they do. And the courts will impose force them. They'll require them to pay my legal fees if I go after the creditor. So the courts are very serious about this. They want the creditors to comply with the automatic stay, and they will punish them seriously if they do not. But one thing that's an advantage too, and you mentioned about preferences and the automatic stay, you know, one thing that's interesting that a lot of people don't realize though, is if you've been garnished, then what we can do oftentimes is we can go back and get back the garnishments that have been taken out of your paycheck or your bank account.
Is that a preference?
90 days. It is a preference, but the nice thing about it is if we're able to protect it with the exemptions we were talking about, if we're able to protect it, that we have enough exemption available to do that, then we can often get it back for the debtor, not for the other creditors.
And what a great move.
It is.
In regards to mortgages and loan modification, because that's mainly probably 90% of the people are trying to protect their homes or modify the mortgages. What's been your experience with trying to modify a first mortgage?
Well, I'll tell you, I have a couple rules that I tell people all the time. Number one is never ever pay anybody to help you modify a mortgage, because the fact is most people, when they try to pay someone to modify a mortgage, that company will call up the mortgage company, and then they'll call up that person and say, okay, call up the mortgage company now and provide them with this documentation, this documentation, and this documentation. Well, you've just wasted $1,000, $2,000, $3,000 that you could have spent to help get caught up on your mortgage payments. And the truth is, a lot of the time the mortgage company won't even talk to these third parties. That's the first thing. The second thing is, and this is really going to be some harsh reality for a lot of people to hear, but all the PR that you hear about the banks working with people and being willing to modify the mortgages, unfortunately, it is just that. It is PR. The banks really are not very friendly in terms of working with people. We hear about these, you know...
When you say PR, that's their public relations move, but
correct.
They do not work with anybody.
It's not the reality. And, you know, we hear about, you know, these programs that are set up by the federal government. You know, I have someone come in every day and tell me, oh, I'm with the Obama program or whatever.
I got that email yesterday.
Yeah, exactly. And the truth is, there is no program. Basically, these quote-unquote programs are just go to the bank and ask them to try to help you out. And if you're counting on the bank to help you out, well, I got a bridge in Brooklyn to sell you.
One of your clients talked to me about a divorce, and they asked me to ask you on the show, because I said I was having you on the show, is if you're going to get a divorce, should you have a discharge in bankruptcy before or after, or in between? What's your advice, general rule?
That's actually a great question. Number one, if you file bankruptcy as a married couple, it costs the same as it does to file separately as individuals per person. So, for example, if you file jointly, you're each going to get a discharge for the same cost as each of you would have to pay individually. So it basically doubles your cost if you file bankruptcy on your own individually. So that's the first thing. And anybody who tells you, by the way, that it's going to cost more because you're filing as a married couple is not being genuine with you. It costs the exact same. Yeah. That's the first thing. The second thing is that any debts that are adjudicated through the divorce decree. So say the divorce court steps in and says, this spouse is going to handle this joint debt, this spouse is going to handle this joint debt. Well, then those joint debts, through one, you know, I could explain if you're interested, but those joint debts end up being non-dischargeable in bankruptcy. So the best thing actually is for you and your spouse, yes, exactly, file bankruptcy prior to the divorce. Then when you get divorced and you don't need to deal with these debts, you can each get on with your lives and not have to worry about these creditors ever coming back at you. And you have the added benefit of paying half the cost to boot.
For the last 30 seconds, quickly on where'd the time go? Debt consolidation.
Debt consolidation really doesn't work. Most of the time, people come to me, they've been making payments to these debt consolidation companies at the same time being garnished by a creditor.
Financial Law Group, do they help repair credit scores?
We absolutely do.
And does that work?
You know, it's over the long term, I can suggest some strategies that do work over time.
Great. Mike Greiner from Financial Law Group over here on Hoover, just north of 12 Mile Road, and author of Bankruptcy 101, an insider's guide to filing bankruptcy by yourself without an attorney. Thank you for being here on Point of Law. You've told us a lot about bankruptcy. And thank you for watching. And I hope you learned something about our point of law today, bankruptcy. We'll see you soon.